Have you seen or noticed any differences between the USCIS and consular processing at U.S. embassies, particularly given the page limits for the E2?
Definitely, definitely. And even though the E2 visa regulations are same or similar between U.S. Consulate, Department of State versus USCIS, these two different agencies behave quite differently. Historically, it's not just recent time. Historically, they've had different emphasis. With the USCIS, their emphasis has always been high scrutiny on source of funds and validation of the expenditures. With the USCIS, as you all know, there's no page limitation. So they expect quite extensive detailed evidence of all the expenditures. And even going into documents, how the description of the expenditures are written and how the fund transfers, how everything lines up, and there are no cash transaction, everything verifiable by bank records. Heavy emphasis on the source of fund, trail of money, proof of expenditure that ties to the qualifying source of the money. USCIS is just incredibly strict on that. Whereas with most US consular posts, most of them have page limitations. So due to that, you're not able to include the detailed documentation. And as a result, their focus, just from my many years of experience, 25 years so far focusing in this area, most of the consular posts seems to focus on marginality, business viability. They don't have the kind of detailed documents on source of funds and the trail of the money due to the page limitation to impose that level of scrutiny. Now, of course, I've seen cases where they issue RFE or 221G requests for more detailed evidence of the source of funds. Those are relatively rare in my experience. Seems to be they focus tremendously on non-marginality and active and operating business at the consulate post.
And do you want to expand, I guess, on your approach to those type of things and maybe examples too? I guess
Definitely,
to your direction.
definitely. So with the USCIS, there is heavy emphasis on making sure from day one, the source of money is vetted and qualified, and the transfer of the money, U.S. enterprise, is carefully strategized, especially from countries where there are difficulty in transferring funds out of the country or there are foreign currency export restrictions. Um, and as well as like money coming from third parties, from donors or lenders, making sure the money comes into the applicant's personal possession and control before investing in the U.S. business. So vetting all that before the client even starts setting up the business in the United States or work on searching for businesses to buy in the United States. The financial vetting is super important if the intention is to apply for a change of status in the United States. Whereas if the client is applying for an embassy E2 visa, I have a heavy emphasis on making sure the client understands, and it varies depending on the consular post, because high scrutiny consular post, for example, Pakistan, some of the U.S. embassy in Middle Eastern countries and South America, they are much higher scrutiny than some of the U.S. embassies in Western and developed countries. Even though all the rules are the same, they have such different personalities. So based on experience, I will advise the client and strategize with them that for your consular post, you need to make sure that the business on the non-marginality, active, real, and operating, because they're not going to accept, based on my experience there, an early stage, small startup speculative business. They're not going to assume you're going to do all that unless they have credible evidence that your projections are credible and realistic. Whereas some of the consulate posts in Western developed countries, for example, one of my favorite ones is Toronto U.S. Consulate. They seem to be very fair and open-minded, and I'm more willing to submit an application there for an earlier startup business because they seem to be more willing to give applicants, entrepreneur, a chance to prove their business concept without a lot of business results already proven. So you really have to look at what consular posts you're dealing with. And nowadays, with the current administration's policy that applicants must apply for U.S. visas in their country of citizenship or residence, there's no more really third country national applications anymore. You can't really form shop. You're stuck with a country where you have citizenship or residence. In fact, I inquired for clarification with the Dubai U.S. consulate because even though UAE is not a treaty country, there are a lot of treaty nationals residing in the UAE. And I clarified with them, what do you guys consider to be a resident of UAE? My client has the UAE Golden Resident Visa. Their response to me is, it's not enough you have a resident visa. You need to be physically domiciled in the UAE to qualify to apply for your E2 visa here. So, this is how they're defining it. And then we have a clear understanding of where we are allowed to apply for the client's E2 visa, and then really look at that consulate at their level of scrutiny and their expectation and build a case around that to satisfy that particular consulate post.
We've been seeing that also on the business plan side, definitely on the revision requests and the kind of details that need to be put in nowadays versus the past. Are you seeing more scrutiny at the initial filing stage, or is the initial questioning showing up more on the RFE side, interviews, renewals, counselor process?
I'm seeing greater scrutiny through the whole spectrum of the E2 visa process, whether it's initial filing or renewal or through the RFEs or at the interview stage. The questionings are more extensive. I'm seeing the questioning going into the individual profile of the applicant equally as much as about the business investment and marginality and the business viability. So now as an attorney, we really have to scrutinize the applicant's personal profile in terms of where they're from, their travel history, whether they've gone to any of the travel banned countries, whether looking at their resume, whether they have any background, their profession or their education, where they have experience in dual use technology that could be seen as a security threat, how much family ties they have in the United States, and how their family immigrated to the United States, so on and so forth. So we have to do an equal amount of vetting of the applicant's personal profile, in addition to advising them on making a qualifying investment.